government is required to do.
No, that NCT
As
is.
per the,
Yes.
no,
Yes.
in general.
In general, of course not, Mullahs. Of course not. That'd be a very dangerous proposition, Mullahs, of law.
No, but these are day-to-day functions.
This is not a day-to-day function. This is minimum eligibility requirement to teach millions of students. Not a day-to-day function, with the greatest respect. It's not a procedural issue. It's a substantive issue.
See, what is troubling us? After all, who has told NCTE to do this? It is not something.
I agree.
It is the central government which is saying.
Yes, yes, yes.
So you can't brush it aside very lightly, say that and bring all those technicalities, regulations, this, that.
I'm not brushing it aside. Certainly.
It has a bearing. It has a.
I'm not brushing it aside, Mullahs. That's why I said that any decision of the minister must be within the framework of the law. Mullahs, it may be the decision of the cabinet also. Must be within the framework of the law. These are all decisions of the central government. Because the cabinet takes several decisions struck down by this court. It may be anybody who makes a decision, but there is a procedure, there is a prescribed procedure. And we're not talking about anything else. We're talking about minimum qualifications. And what the minister says is this is a higher qualification.
There, let's say the main argument is section 29 of NCT Act, which they say once the central government tells them to do, it is binding upon NCT. So NCT is saying, look, our hands are tied. Central government said that, we have done.
Correct. Well, this is now for your lordship to decide whether this is a fair methodology adopted under a controlled.
No, not fair. It is section 29.
No, section 29 doesn't say that you can change the minimum.
Hold on.
One second. It doesn't. It only says the policy decisions.
Let's see.
29 doesn't say anything of that sort. (39) Council shall, in the discharge of its duties under this Act, in discharge of its functions and duties under this Act, be bound by such directions on questions of policy, as the central government may give in writing to it from time to time.
So, prescribing qualification is not a matter of policy.
No. Prescribing minimum qualification is not a matter of policy, brother.
And what is it?
I'm sorry, it is which person in the teaching profession is appropriate to teach which class. It's an academic policy. It's an academic matter. It's not a matter of policy. Policy is, Mullahs, let me give you examples of policy. Let me give you an example. During COVID, Mullahs, how to function? Just outside the Act, matter of policy. Mullahs, pollution, central government can say, look, Delhi, schools will be closed. As it has happened, that the winter break has been extended, matter of policy. Matter of policy that, look, every school must also admit challenged children. Is a matter of policy. These are all matters of policy.
This function is already ascribed.
This function is already, Mullahs, under the statute given to an academic authority which 23(1) sets out, which has to set minimum qualifications. Because, Mullahs, otherwise, any matter will be a matter of policy. But the ambit of a policy is without contours, then any matter will be a matter of policy because the central government has decided.
Ultimately, it comes to the court, but right, subsection 2 says that.
No, but it does. But that's the point, Mullahs. That's the point. In fact, it has to say in the context of 23(1) and 2. And then 12 and 12A.
Yes, special access.
Your Lordship may kindly
See 12 and 12A, Mullahs?
Yes,
A minute, please.
only half a minute.
Please.
1 second. 12A, Mullahs. Power of Council for the purposes of maintaining standards of education. Council may by regulations determine qualifications or purpose of being recruited as teachers and any pre-primary, primary, upper primary, secondary, senior secondary, intermediate. Is this a matter of policy?
They will find out ultimately it cannot be up.
In my treaty, all statutes you will find this as a matter of policy directions can be issued. But you will never find a direction contrary to the statutory responsibility. Take, for example, under the Electricity Act, can a matter of policy be issued that, look, as far as the particular tariff that is to be decided, central minister says this tariff for the purposes of supply to the distribution companies, to retailers would be such. Can a minister say that? There will be provisions even under the Electricity Act.
There a tariff fixation mechanism has been laid down.
That's right, here also. Exactly that, Manoj. Where is the commission? D.EL.ED.
This is also
Right, Manoj? There is a whole process that goes on there. Similarly here, what's
No,
the...
but no, under the Electricity Act, also there is a powers are with the government, state government, finally, to fix, even ask the regulatory authority.
No, Manoj. They go to the regulatory mechanism.
There is a provision in the Electricity Act, some provision. But anyway, the state government can it not tell when the tariff is being fixed that look, this is an area, let's say in the hilly areas, people are poor, they may be given this unit free. And the regulatory authority does it.
Correct. Now what happens?
Will it be wrong?
No, let me just answer that since your lordship posed that question to me. You say all consumers of such and such will get free milk. You can say that's a matter of policy. That's a matter of policy that consumers, say below the poverty line, will get electricity free.
Sorry.
It's a matter of policy. But that's not fixing the tariff. When the tariff is to be fixed, Manoj, it has to go to the commission.
All right. Even if it says fixation of tariff,
Yes.
it says that, let's say, I'll give an example of Uttarakhand.
Yes.
That people who are living in that high altitude areas,
Correct.
and their tariff should be, general tariff is let's say 10 rupees a unit.
Yes.
We charge them only 1 rupee.
Correct. I'll tell you, lordship, why. Because that amount will be then subsidized to the generating company.
No, but will it be wrong for the state
No,
government?
it won't be. It won't be.
So if you draw the same analogy
No, you
here,
can't, because there is a statute here for minimum qualifications, Manoj.
oh,
There is no such thing there. Your lordship is right. Your lordship is absolutely right.
that is
That is the problem. Here, Manoj, there is a statutory provision. Manoj, what happens in all the electricity cases, Manoj, the distribution companies are then subsidized by the government. Right, to make up for the loss.
yes.
So that as a matter of policy, the government bears it.
that's why of the tariff.
That's why, Manoj. That's why it's all right. The tariff will be fixed. The tariff will still be realized. But the government says you supply it at this rate. That's all. We will take care of the distribution companies if the cost is so much. So in the order of the D.EL.ED, that will come. But here, Manoj, the whole issue is entirely different. And Manoj, in any case, now I've shown to your lordships, minimum qualifications are to be fixed. B.ED is a higher qualification. If that is the minimum qualification, then others can't. Now, Manoj, just quickly I finish with the judgment now, Manoj. Nothing more to be done. Can he take the judgment now? It's 5 minutes, I'll finish. Now, kindly look at page 145 of the Devesh Sharma, the impugned order. Paragraph 20, which I read to your lordships earlier. The R.D. Rastogi, learned additional Solicitor General appearing for NCT, has placed before us further correspondence which took place between NCTE and MHRD in this regard. These documents are taken on board. Perusal of these documents would show that after the minister put his remarks on 11/4/2018, those remarks are 11/4/2018, which I showed to your lordship. Your lordships will note that date. That is 11/4/18. It is part of the record. I showed to your lordships, I'll just give you the date again. Page. Just give me 108. The writing of the minister. The writing of the minister, this is 11.4. And my learned friend says it's not part of the record.
Let's leave it.
MHRD wrote to NCT pointing out that the minister has directed NCT to amend the qualifications and make B.ED also an eligibility for teaching primary level with the proviso of passing the module within 2 years. But it's not an eligibility, it is minimum qualification. Everybody is eligible that way, Malas. Even I as a lawyer am eligible to teach children because I have a law degree, Malas. We also note that in a meeting of 28/5/2018, the officials of MHRD and minister concerned discussed and deliberated the issues and decided to recognize B.ED degree as an additional eligibility criteria. This whole concept of eligibility is alien to 23(1) and 2 for appointment of a post of primary school teachers. Now let's kindly over the page. At the bottom of 146, para 21, the decision was summed up in a note on 29/5/2018. That please place on file the letter from NCT which is handed over to the HRM by the MS NCT during the meeting, details of which have been referred to in the draft reply. The meeting clearly took the decision that we are the facts presented by the Commissioner KV, and since the NCT did not have any objection to permit KV schools to recruit primary teachers they had objection, I showed to your lordships, that only if you don't have enough teachers. Paragraph 5. Then there should be no objection to extending this to other schools, and therefore this ministry could issue directions under section 29. That's how 29 comes in the list. Right, then the advertisement, leave that out. Now kindly come to page 153. 153. No, leave that. I just want to read that. I'll come. But it's 153, 6 lines from the top. In fact, the learned ASG, Lordship has that? In fact, the learned ASG Rastogi, Mr. Rastogi, has repeatedly argued before us that the powers are exercised by the NCT under 23(1) and not 23(2). So this is not a case of relaxation. If we proceed on such basis, the immediate question of the authority of the central government to mandate NCT to make a decision change would arise. The RT does not give power to the central government to give any such directions to the NCT. That's the finding. That's the conclusion. Then at the bottom, 5 lines at the bottom. Thus, the power of the central government to issue guidelines under subsection 1 of 35 of the RT does not extend to the NCT as an academic authority notified under subsection 1 of 23. A reference, of course, was made to 29 for such purpose. Under subsection 1 of 29, NCT shall in discharge of its functions and duties under the Act, be bound by such directions of policy, whereas we have already dealt with it. Then, middle of the page, about 10th line from the bottom of the first paragraph, it is beyond dispute. Joseph has that? That very paragraph, but 10th line from the bottom, it is beyond dispute that the amendment is not of the original work of the NCT. In fact, the opinion of the NCT was that B.ED may be recognized as an alternative qualification for the purpose of where adequate number of otherwise qualified candidates are in short supply. That your lordship is aware. Overruling such opinion of the NCT, the ministry HRD mandated on 11th of April that B.ED may be recognized as the additional qualification. This is not a case of additional qualifications. It's a case not of eligibility, but of minimum standards. And then, ultimately, finally, the bridge course is there. And then finally, the court notes that there are enough vacancies. Let's show that. Where is that finding? So that is 1 second, just one. We have 3,35,000. 158. Page 158, Madas. Yes.
What's next?
158. 8. Yes, this is very important. 158, Madas. Then I've done 4 o'clock. Saying Advocate General appearing, bottom of 158.
10 minutes.
158 says, Mothers, Advocate General.
Take around 10-15 minutes, then we'll continue.
No, Mothers, I'm finished. I've done. Finished. I just worked. This is the last thing. Says Advocate General appearing for the state government who had stated that in our REIT conducted on 26/9/21 for primary, upper primary school teachers, 350,000 odd candidates holding the qualifications of BSTC, D.EL.ED had participated against 18,854. So 350,000 against 18,850 posts. So you have qualified teachers under the minimum qualifications prescribed by NCT, and you want to deny those teachers. And say appoint higher qualified teachers because I changed the eligibility condition. We're not talking about eligibility condition. And with bridge course, which today is not available. So where are we? Where are we going?
And condition within 2 years of appointment, you have to pass it.
That's also 2 years old. So this is, I'm sorry to say, Manas, what can I say? Ministers, Manas, are ministers, but they are accountable. They are governed. They are governed by law. They are not the law of this country. They don't represent the law. They are governed by it and they are bound by it. That's all I have to say. Deeply. Your Honor, may excuse my absence tomorrow. I've been another.
Yes. Tomorrow we'll take this up after the miscellaneous matters.
No, not 2 o'clock. Let it be in the morning, whenever your lordship finishes, because
Yes.
then we can possibly finish.
Hard and adjourn till morning. We taken up for hearing after the miscellaneous matters.
So tomorrow.
The rest of the matters that are on board, Murad, will carried over tomorrow.
We have already structured.
Tomorrow.
So the rest of the matters will be after this.
Yes.
Perfect plan.
Grateful.
Charge matters.
Necessarily carry.
Regular matters.
The regular matters will be discharged. They'll come tomorrow after this.
Yes. Grateful.
No better than